I particularly appreciated, the possibility to focus on a blue sky approach as well. Actually, I think I'm adopting an approach which is even above the clouds very much, and is going to depart neatly from what we discussed so far. Mainly, I'm trying to look at other areas of law and try to see how regulation of intermediaries can come into play from those areas. Mainly focusing on data protection law and competition, antitrust law. So the title of this presentation is Architectural Responsibility, because I think it's important to focus on what are the critical architectures for the algorithmic societies. It's a term which I borrowed from Jack Balkin, of course, referring to a society that is based on very much on big data and algorithms. So this picture, normally you would start ideally a presentation with a joke. Unfortunately, it's not a joke. It's an image of the hospital of L'Aquila after earthquake in 2012. And here, a whole section of the hospital collapsed. And the problem was that a lot of people, had to deal with the earthquake. And there was no place basically to heal these people. So that's what I refer to as a critical infrastructure. And thinking about the role of an architect, when he designs a structure like an hospital, perhaps we should have a higher duty of care, a higher responsibility when it comes to these critical architectures. So I think, in general, we can focus on a wide range of approaches when it comes to critical infrastructures, and probably the laxest approach is self-regulation, and on the other hand, you have command and control regulations. Intermediary liability is certainly somewhere in between. But basically, I would argue that you need to take into account, the competition in the market and whether there is a market failure. This should inform how you design a regulation. And I think lately we have seen a lot of initiatives that focus on a co-regulatory approach. So the state or the European Commission tries to set out some principles that then the private sector will need to follow and implement. Generally, there is some sort of oversight, periodical check of how the companies are doing. A good example of this is the recent code of conduct on hate speech with certain IT companies. But there are certain safeguards that are recognized as necessary elements of a co-regulatory framework. So one of those is that the objectives are clear. Another one is that the design of this framework is compatible with fundamental rights. And a third important element is also recognizing the different capabilities of the actors that are involved in this framework. So when it comes to ISPs, we might want to focus on different roles and responsibilities than when it comes to hosting providers. But also in terms of financial capabilities, we should recognize that some actors, are better equipped to fulfill certain tasks. And the problem is there that when you leave the choice of a measure to the intermediary without sufficient guidance on how to implement that choice, this might have, a detrimental effect on fundamental rights. And here I like a quote by Advocate General Spooner in the McFadden case, where he said indeed that when an obligation imposed on intermediary to take a certain measure is a source of legal uncertainty, that should not be considered compatible with the Charter of Fundamental Rights. So the point there is that the state should not only define clear criteria, but also maintain an adequate supervision over how the regulatory measures are going to be taken. And this is in particular where the mandate in itself is not entirely clear. So now let's see, we have seen the general principles. Now I want to focus on how this duty to respect and protect human rights is being fulfilled in a market by companies through their terms of service. So that's a partial view, but I want to just discuss this experiment that we did. So it was a project with the Center for Technology and Society and the Fundação Getúlio Vargas in Rio de Janeiro, and it was in partnership with the Council of Europe. We basically reviewed the terms of service of 50 online platforms of various types, and we tried to creatively define the standards that would apply in the private sector if we had to draw the consequences from the obligation that apply to state, for private intermediaries. So we focus on 3 rights, mainly freedom of expression, privacy, and due process. So on freedom of expression, we have 52% of companies that say that they do not notify removal of content, 88% delete accounts without notification. On privacy as well, we have several findings that are concerning from the perspective of whether they adopt basic principles such as data minimization, but also aggregating information between different services, sharing and allowing the tracking on their properties, etc. You can find the studies online. Also quite illustrative, quite instructive was to find that the rights of consumers to access a court, sue in their own jurisdiction, were curtailed, and also they were not informed adequately before any change of the terms of service. This, by the way, fed into the consultation that the European Commission was doing, and I think, I don't know, I want to be optimistic about it, and I think they took this into account now that they're focusing on a new initiative on platform fairness. I think that in general there is now a greater concern by the European Commission over what the companies put on the terms of service. We know that nobody reads it, but still there should be an indication of what are the rights and principles that apply, the law of the platform. So lately you had an action taken within the Consumer Protection Cooperation Network, which is a network of national consumer protection authorities that took issue with the terms of service of various social media companies. And some of the issues that they took were related to access to court, indeed. Some others were with regard to a disclaimer of liability. But also importantly, I think the last one, which is platforms should identify clearly when they're communicating for commercial purposes, when the content that you're seeing and receiving is basically skewed for commercial purposes. And this increasingly applies when we are talking about companies that mediate the information that consumers receive in the market. And we'll see, in the case of Google, this was basically one of the reasons for the whole abuse that was led to a fine for antitrust enforcement. So the companies took notice of this. They said, okay, we are going to follow what you are requesting us to do. And so by a year later, by February 2018, the Commission came out with another communication and said, consumers, you should be happy because companies now have taken on board our suggestion. They have changed their terms of service, and all these rights are now available to you. So we'll see. Certainly it's a good step. The problem, you might think, well, here the Commission just went after some companies, social media companies, and it's a type of command and control regulation, so the strongest type of intervention. Actually, this is really applying a law that we already have, consumer protection law, and it's simply not sufficiently enforced in the market. So there is a problem of market failure, and here if we see, this is a score that we got in this study for freedom of expression. So we gave a score ranging from -2 to +2 for each of the aspects, so freedom of expression, privacy, and due process. And you can see here, freedom of expression, you have just 3 companies that are basically positive. This is only the right part of the screen. I couldn't get the whole thing, but all the others are negative. On due process, we have 2 companies that, no, 3 also here, that are above 0. Whereas on privacy, we have a much better score. Okay, so this might, suggest that perhaps there is a greater awareness in the market about, the importance of privacy, and there is basically a culture of taking this into account when marketing, at least in terms of service, what you are doing. And I think that the GDPR and the whole shift of privacy towards a risk-based approach, towards greater accountability for entities who are processing and controlling personal data, suggests that there is basically a shifting towards the market taking the lead on respecting the law, which is different from saying, I will just wait and act when I think there is a violation. You are not required to do anything at all. You are previously the duties were limited. Now there is also an opportunities for companies to basically start and market their services towards privacy compliance. So the privacy impact assessment, the principle of accountability means that I, as a data controller, need to adopt all technical and organizational measures to ensure that I'm able to comply, and I have a duty to be able to demonstrate that. And so I think that this indicates that there will be a new class of professionals that will be specializing on taking care of these regulatory obligations. And we are likely to see also in the market some companies starting to offer services for privacy compliance, and people relying on the third parties for managing personal information and privacy more generally. Why I say that the GDPR also creates some kind of market for this is that it also creates the incentives for some companies in the market to serve consumers and make them understand how the market works in a better way. So this is mainly through 2 provisions that have been introduced by the data protection regulation. So one is the so-called right to explanation. There's a huge discussion about it, but basically it establishes, it's not entirely new right, but it's reinforced by the general data protection regulation. So it says that whenever there is an automated decision that significantly impacts individuals, then basically this should be legitimated through either explicit consent or because of a contract between the data subject and the data controller. And these situations, in any case, should provide a minimum safeguards for the data subjects. This safeguard implies at least the right to obtain human intervention on the part of the controller, the right to express his or her point of view, and the right to contest the decision. Then in the recitals of the regulation, there is a reference to this so-called right to explanation, and it is discussed whether this creates an entire new right, or it is, some people argue that it's implicit in this right to contest, for example, because you need the explanation in order to be able to contest the decision. Regardless, it is also part of a whole ecosystem that provides more information to the individuals. So also Article 13 and 14 establish the duty to inform for any automated decision-making that is happening of the type that I described earlier, and at least in those cases, meaningful information about the logic involved, the significance and the envisaged consequences for a data subject. Similarly, you can also access, so you can request to access the data that data controller has about you as a data subject, and this includes also this kind of information. So the whole ecosystem creates, an ability of data subject to better understand how the market works. And here there's an example for the case of credit scoring. You give some information about what are the factors that you're using to determine credit scoring. You say that for certain kind of factors, you might lead to denial of credit. And then the data subject, basically according to the so-called right to explanation, he would have the right, I think, to contest, why, given these factors and given the data that you have about me, I'm not getting the decision that I should be getting. So give me an explanation, or at least a counterfactual that suggests what I should change to get that result. So how the companies are doing this, which to some extent, as I said, there was already a right to not to be subject to automated decision-making. Now there is this right to explanation explicitly laid out in the regulation, but companies already had some duty of transparency. So what they were providing was really the minimum transparency. And this is, I requested to Twitter to see why am I seeing something called competition feed, which is an automatic feed that informs me about competition law news. And the reason that they gave was because you are located in Belgium. I don't think, this is sufficient as an explanation, right? Similarly, someone told me they received the advertisement of Max Schrems, the new entity that is forming to litigate, and the reason was because he speaks English. So these are not the right. I know that there is something about my interest for competition law that doesn't come there, and then you can click about the advertising categories that have been associated with me, and they have all sort of stuff about autos clicked on that has nothing to do with my thesis. So it's done, just for formally saying that they fulfill the requirement. So the second right that is important, and I think especially when you combine the two, is the right to data portability. So the right to receive personal information in a structured, commonly used, and machine-readable format, and transfer it from one data controller to another. So it applies in certain limited circumstances. We're not going to dwell on that. But this, I think, gives the power to certain entities to get the data, so promise to gather your data and also send some right to explanation request in order to say what's going on with what the decisions that are being taken about you, given the data that you have. They help consumers understanding, and they help also have some sort of collective intelligence because you can submit multiple requests. And this is the first embryonic phase, I think, of a new category of intermediaries, which I would call infomediaries, because they help consumers to get information in the market. Well, you might have heard about personal data stores. So what they do is they ask the data to some data generating company. For example, it might be your car manufacturer, and they allow third parties such as a mechanic to get access to those data. So you have to give the permission as you are the data subject within the personal data store. And you are able in that way to go from one provider to another and see who gives you the best deal. Okay, so why I think this is important, it connects to the conversation that we are making, because these intermediaries will be, I think, if they take on, it will be the new focal point for data protection enforcement in the market. So the question is, will they be controllers and therefore have all these obligations from data protection regulation? And we want them to have some obligations to make sure that they comply and that they're trustworthy. So what is the criterion that has been established for determining whether someone is a controller is whether it has basically control over the means of purposes, but in particular the effective means of processing, such as selecting the data to be processed or the third parties that might have access to it. So I think here we have some connection with the discussion of intermediary liability, especially when it comes to defining whether someone is a joint controller. So you focus on basically control, whether they give prior instruction that is sufficiently exhaustive. If they do, then they're going to be the only controller. If they do not, then the other entity is going to be, instead of merely an intermediary, is going to be a joint controller as well. And the latest Facebook Ireland case, so this was about an admin page of Facebook, and there was the discussion by the Advocate General that basically both the administrator of the page and Facebook should be data controllers. Well, basically, one of the points was if we ensure that these entities that are powerful comply with data protection law, this will have a ripple effect, and there will be compliance more generally. Okay, so I will, in the interest of time, given that we are already out late, I will not focus on the obvious resemblance of the criteria, material benefit and necessary intervention into defining whether this entity are joint controller. It obviously resembles the intermediary liability discussion, but the point there is that if they are trying to justify an extension of the duty of controllers to other entities, and the question is whether benefit should really play a role at all. Probably not. The Advocate General tries to create some justification for extending the obligations in this case, and I think material benefit is not the right one. We should focus maybe on who has access to the essential and dominant infrastructures. So that's where I basically land on the competition law side. So Google was recently found to have violated antitrust law for having given preferential treatment to its own services over comparison shopping services of its competitors. So here, the order was simply you should reestablish equal treatment under all possible criteria, and Google started as part of the remedy to offer an auction of the first slot, which is the sponsor slot, to other services. And the result is that right now, instead of all results are of Google, only 99% are of Google. So here, the problem is that the Commission said there is not enough transparency with regard both to consumers, what they perceive, and the competitors when they can be demoted. So the point is, Google is not only putting in self-serve first, but it's demoting competitors from the results, and it's not clear on what basis. So the Commission took issue with that. It took issue also with the fact that consumers are not able to understand that this is a sponsored result, even if it's written. Basically, there is insufficient transparency. And what is interesting, and I think of relevant for this discussion, is they focus on the distinction between active and passive. It's the first time that in antitrust this is being used. And basically to distinguish what Google produces through its result that could be discriminatory and favor itself from basically tweaking the results and putting itself first, actively. So this would be active intervention in the results, whereas passive would be simply, it could be disparate treatment. It didn't rule out that a disparate treatment with formal compliance of equality would still possibly violate antitrust law. But I think it leaves this broader question, that is about what limit do we want to put there. So do these companies have to self-police, the effects of the algorithm for any possible preferential treatment that they give, even indeed when it's not a formal distinction, but it can be the result of the application of the algorithm. So you have the article in the handbook, but I think we should think also in this area about a possible safe harbor. So what these companies could do is they could run the algorithms ex ante and try to establish whether there is any possible bias, maintain a record that they could give for inspection, so similar to a data protection assessment, an algorithmic impact assessment, and possibly we could also establish ex post some notice and adjustment procedure over the results. If a competitor feels that it's not being fairly treated in the ranking, it could send a notice, and then either Google or whatever other company justifies it on the basis of a personalized explanation to the competitor, or it needs to readjust. So that it could be perhaps some also broader principle that we can use in other areas. So an algorithmic impact assessment. And since my task was also for all of us in this panel, I think it was also to mention about the Brexit and possible UK specificity. I throw that in. I mean, we have seen now two possible entry points for regulation. One is data protection law, possibly the right to explanation. The other one is antitrust. And mainly what I was referring to is defining the critical infrastructure in antitrust terms, so who has the dominant position. And then, similar to telecommunication regulation, we apply a concept of substantial market power and certain duties to those companies. Then I suggested that it could be a safe harbor that maybe relies on algorithmic impact assessment. Another safe harbor which could be useful to extend to various situations is the one that in the UK you have with the Defamation Act, where companies are not liable for defamatory statement if they prove that they allow the users to identify, they could enable the identification of who has posted the material, and they have a process of notice and takedown, basically. So why is this limited to defamation? It's not clear. We could perhaps extend it to other areas and maybe also to the critical architectures. So with that, I hope it was blue sky enough, and I leave it.